Donald Trump is not your typical witness, but it is not every day that a witness declares in a deposition that he is not sexually attracted to the opposing counsel. He spontaneously declares that Roberta Kaplan, attorney for E. Jean Carroll, wouldn't be a choice of mine, either, to be honest with you, just when you think he has reached the depths of depravity. I hope I haven't offended you. He continued, adding, even if you weren't suing me, I would have no interest, okay? Even if you weren't suing me, I would have no interest in you, he said. We want to know how you feel about the culture and policies of a law firm. Gross. Nevertheless, this is very typical of a man who claims that he could not possibly have harmed a woman because she is not his type. Would the opposite inference hold up? The former president appears to have admitted that powerful men sexually assault women who are their type, so take what you will from that statement. That deposition on October 19 was absurd, even for Trump. Trump acknowledged that he had called Carroll a Democratic operative without any evidence because he had the right to be insulting and mistook a photo of Carroll for his second wife, Marla Maples, contradicting his repeated assertions that the plaintiff is not his type. He also promised to sue Kaplan and Carroll very strongly. It was disgusting and in line with the tone of this lawsuit. We still await the D.C. Court of Appeals' decision on whether Trump was acting within the scope of his presidential employment when he made the initial defamatory allegation that is the subject of the 2019 suit. Carroll, just 10 weeks before the two defamation cases are scheduled to go to trial. In the meantime, the parties are at odds over expert witnesses. Under the newly enacted New York Adult Survivors Act, Carroll outlined a second defamation count for Trump's more recent defamatory statements and a sexual battery count for the alleged assault in the mid-1990s in her 2022 complaint. Carroll 2. Under the battery claim, Carroll only claims that she was unable to form sexual relationships following the attack. She is not claiming PTSD or any other disorder that can be diagnosed. She testified that the light had gone out while being questioned by Alina Habba, Trump's attorney. This contrasts with the portrayal of a crazed woman fabricating a lie out of nothing as part of an elaborate hoax to bring him down that Trump has consistently sought to paint, and it puts his experts in a box as they attempt to discredit her. In point of fact, it would appear that Trump is having a hard time finding someone who can pull that off. This is especially true given that he has clearly run out of patience with Judge Kaplan, who has already accused Trump's lawyers of attempting to improperly delay the trial and appears unwilling to give them any additional leeway. Joseph Tacopina, Trump's new attorney, made a promise to the court less than 2 weeks ago that there would be no more heists. He promised, if you say start tomorrow, I'll be ready. I'm trying it in April, if you say April. I am not fleeing this responsibility. Lexis Search Advantage Transactional combines internal and external research to speed up the development of better deals. In order to allow his expert witness to carry out an independent medical examination to assess Carroll's injuries in connection with the battery claim, Tacopina obtained a brief delay. However, the court issued an order restricting the examiners to appropriate metrics to evaluate the issues of whether plaintiff was emotionally harmed by the alleged sexual assault, and if so, to what extent, and whether she is pretending or exaggerating her injuries, after substituting in a team of experts who aimed to subject the 79-year-old plaintiff to a battery of tests to evaluate her for malingering. The court explicitly forbade inquiries intended to assess Carroll's rape claims, credibility. The experts then consulted their own legal counsel on the day of the examination and suddenly remembered that they were in an ethical conflict. Or on the other hand, maybe a planning struggle. Or perhaps they were required to wash their hair. The specific problem is a mystery. They wrote, we do not now believe that it would be ethically permissible for us to proceed with the evaluation as limited by the current court order. They added that they came to their decision Sunday evening, after hours of reflection and consultation with senior colleagues and 3 attorneys. To find a new expert examiner, Tacopina is now seeking yet another delay. In the meantime, the parties are debating whether the infamous Access Hollywood tape, as well as the testimony of 2 other women who claim that Trump assaulted them in similar circumstances, can be used as